at that proceeding and even in this proceeding, blaming me for his incurring Mr. Doyle's cost, blaming me personally for that. That's offensive.
Page 4 is A18-781255, Harris versus Del Casal. Morning, Mr. Harris.
Good morning, Your Honor.
Mr. Needham, you there?
I am. Thank you, Your Honor.
Thank you.
Alda Anderson for Miss
Anderson, good to see you. All right, I have plaintiff's motion application for attorney fees, interest, and costs. Mr. Harris, here's my issues in regards to this, as I'm sure you're aware. The Nevada Supreme Court has made it abundantly clear to litigants that if you are a pro se attorney representing yourself, you cannot collect attorney fees on your own behalf for the work that you have performed. I didn't see any argument in regards to your opposition to that. The case law is abundantly clear to this court that pro se attorneys cannot collect for their own attorney fees when they're representing themselves.
I think the only distinguishing factor I pointed out in the reply, Judge, was that this case can be distinguished, and I agree with you, and I'm well aware of the case law. This case is distinguished in that my firm and myself were involved in this, and it wasn't just me representing my firm, or it wasn't just my firm.
Mr. Doyle was here presently, but the problem is you put Mr. Doyle's attorney fees in as a memorandum of costs.
Well, I also included it in this as fees requests.
Right, but
well.
the thing is, then we go through, and then the court has to weigh the Brunzell factors, and I got a great. I mean, as far as your history and your professional conduct and your background, it was fabulous. Lays it all out, would give it to me. Then I've got Mr. Doyle, and I've got a statement as to his fees and costs. I don't have a problem making a ruling on his fees and costs, and that was much different than yours. I mean, his fees and costs were the tune of what, $8,000 and change, versus the $160,000 that you were requesting on your own behalf for your work, because that's how you did it under Brunzell.
I understand, Your Honor. And that was the only distinguishing factor that I wanted to point out to the court, was that the Supreme Court has been very clear when it was a single party, but not when it was both parties involved, as far as an individual and a firm.
Okay.
There's been no opposition filed by Mr. Franklin that I would point out to the motion either.
There was actually a joinder. She did do a joinder, I believe, to the opposition.
I believe it was late, but
She did a joinder.
fair enough, Your Honor.
Okay.
With regard, I don't know.
Go on to anything else you wanted to do?
Yeah, the second part was that I calculated the interest as of October. It was $7,097, and we're requesting that be awarded, Your Honor. Mr. Doyle's fees in the amount of $8,640. I would just submit to the court that you were able to observe that Mr. Doyle came in and worked. As far as the Brunzell factors go, they would be applicable. I would think you would be able to make that determination that certainly the amount of time and effort that went into this, Judge, based upon what you were able to observe, was that it's a fair amount that we're requesting on behalf of Mr. Doyle, the $8,640. And I just asked, Judge, I understand. I guess I was looking for a clarification on the offers of judgment. I still believe that they can be considered because they do lay out the effort, and it was a rock solid effort to settle the case.
The problem with offers of judgment is when you make an offer of judgment for a monetary and then you throw in a secondary portion of it, i.e. asking for injunctive relief. Not the way the statute's written. It doesn't allow for those types of additional provisions in an offer of judgment. An offer of judgment that asks for both monetary relief and injunctive relief is not a proper offer of judgment. The Nevada Supreme Court has made that abundantly clear also. Anytime you put those, what they refer to as contingencies on them, it no longer is a valid offer of judgment. As far as regarding as prevailing parties, counsel, you prevailed. I understand that they're trying to make this argument that some of the alternative theories you didn't prevail on. I understand that. But when a plaintiff prevails on a theory, they're the prevailing party. The court doesn't go in and say, well, look, the jury gave you 1 out of 20, therefore you're not the prevailing party because, as Mr. Needham probably says, you would be 1 in 19. That's not the way the court looks at that. The court looks at it as who prevailed at the time of the trial, and that, I think, is obvious. Counsel, Mr. Needham, you want to speak first? Since Alda, you did an adjoinder, so I'll let Mr. Needham speak.
Mr. Needham, go forward. Mr. Needham.
Mr. Needham, go ahead. Oh, I'm sorry, we muted you. Go ahead. We got to finish.
I am unmuted.
Yeah,
No,
thank
thank
you
you.
very much.
Should I proceed? Okay.
Yes, sir.
It is in regard to the Doyle issue, Attorney Doyle, as the court pointed out, Mr. Harris, for whatever reason, put that under his cost memorandum. And I'm not sure why he did that. That's clearly an attorney's fee. And but we know that if you put it as a cost, if someone doesn't file a motion to retax, and that's the reason why I filed the motion to retax, and you have like 3 days to do that. If you don't file that motion to retax, there's a good likelihood that would have been granted. So there may have been a reason why Mr. Harris put Doyle there, and it was aggressive. And so I had to therefore file this motion to retax, which shouldn't have been necessary, but I had to do that. In regard to, so I think, and what really was troubling was Mr. Harris's argument at that proceeding, and even in this proceeding, blaming me for his incurring Mr. Doyle's cost, blaming me personally for that. That's offensive. I don't think, because of those 2 points I just raised right there, I don't think Doyle's plaintiff should be rewarded or even considered for that. This extra Doyle's invoice, Mr. Attorney Doyle's invoice. Even if those were reasonable, Mr. Doyle, there still has to be a basis for attorney's fees. The court already pointed out the offers of judgment are invalid. So on those grounds, I feel that the court shouldn't consider Mr. Doyle's attorney's fees. There was no
it may be
Brunzel
that the
factor.
offer of judgment was invalid, counsel, but what about the argument that the court has already basically said that Mr. Harris was the prevailing party?
He would have to show a basis for that. It has to be a statute or some rule to get attorney's fees. And the court pointed out there was no Brunzel analysis whatsoever for Mr. Doyle. There has to be. There would have to be a separate motion brought on behalf of that bill. And there has to be a basis for attorney's fees, Your Honor. Even though he's prevailed, there still has to be a basis for attorney's fees. That would be that's my argument, Your Honor.
Prevailing usually is a basis, counselor, but go ahead, Mr. Harris. Respond.
I just would respond, Your Honor, that the statute is 18010.2b. That is the prevailing party statute that Mr. Needham was not referring to or was.
But how do I weigh Mr. Doyle's Brunzel factors based upon what I was provided? I mean, like I said, yours lays it out perfectly. If you had, if your argument for your fees had been the same for Mr. Doyle's, then I wouldn't have any issue with it. But the problem is I've got a request for attorney fees, which then requires me to do the Brunzel factors. And it just recently the Nevada Supreme Court said even my 30 years of experience is not enough to weigh. I have to actually go step by step and lay it out. That 30 years of practice is not enough to weigh the Brunzel factors. But how would I even do that based upon what I was provided?
I appreciate your position, Your Honor. Well, I guess I would ask for leave at this point then to supplement my motion with the Brunzel factors specifically directed towards Mr. Doyle. And I certainly can do that. And we can detail and break that out exactly what his level of experience is or whatever is required.
They're in the Brunzel factors.
But I think that really with regard to the Brunzel factors, the only issue that would be addressed on Mr. Doyle would be his level of experience, how many years he's been in, and whether or not the fees charged were reasonable with regard to his level of experience. And I don't think any of the other factors would be less applicable to him as far as the outcome and those.
And I agree with you. The problem is I can't even get into the Brunzel factors unless they're given to me, unless the evidence in regards to those factors that the Nevada Supreme Court say are essential for the judge to review. Right now, what would I be reviewing?
And I guess I would just ask for leave, I guess, to supplement then, yeah, with regard to Mr. Doyle only, Your Honor.
In regards to the attorney fees requested on behalf of Mr. Harris for his own work, it is denied as an attorney who represents himself cannot receive attorney fees pursuant to the Nevada Supreme Court's rulings. However, the court will allow 15 days for Mr. Harris to supplement his briefing in regards to the Brunzel factors as they apply to Mr. Doyle and his participation. In regards to the costs that were set forth, in plaintiff's motions are hereby granted. The interest is hereby granted. What I would suggest, counsel, is we hold off until you do your order until after the supplemental briefing. The 15 days to do the supplemental briefing is how long, Ms. Clerk? Give us a date.
January 19th.
Okay,
Just for the record.
oh, hold on, I haven't finished yet. I'm going to allow 15 days, and then I'm going to give everybody 10 days to do an opposition to that matter. Okay? Now, Ms. Ashley, you have anything else?
Yes,
Okay.
I wanted to say something. I object to the request for the continuance
Sure.
because Mr. Harris included Mr. Doyle's fees in his cost. He had an opportunity to amend his motion for legal fees. This has been going on since October. I think he filed it. And I think it's unfair. If you notice what I have been doing to save my client money is to join. And so to have him come back here again when Mr. Harris failed to having been told that he would not be getting, that Mr. Doyle's fees were not cost, to have put it in there, I think it's unfair.
Well, and I would agree with you, Ms. Anderson, if the parties were all timely in their oppositions and their joinders. But when I have parties who are not timely in their oppositions and joinders, how am I now going to say I'm going to hold someone to a very strict regimen of time and allow joinders that are not filed timely?
Your Honor, I don't think that's really, I mean, that's...
It's not relevant if one party doesn't abide by the rules, but the other party should be held to the rules strictly. Counsel, you teach this and you understand equity better than anyone.
No, I understand what you're saying, Judge. I'm still, for the record, I understand your ruling, but for the record, I'm objecting.
Okay, I understand. All right, and then let's just go ahead and have a hearing set forth. But you have until the 19th, Mr. Harris, to do a revised, or you can call it amended, to your motion for fees and costs. Mr. Needham, I'll give you 10 days, and Ms. Anderson 10 days to file any oppositions there too. That date
Your
is...
Honor, I did have one point. Your Honor said he granted the cost today, but at the last hearing, we already addressed the cost issue was already resolved, and Mr. Harris already prepared an order to that effect. So I think the court's already
I
granted.
understand that. I just wanted to make sure because
Okay.
it was raised today that I'm just reaffirming that because it was raised
Okay.
today, Mr. Needham, and I appreciate that.
Yeah, and I guess the only issue I had is the motion had, it seemed like I just want to be sure that's all. I just want to point that out. Thank you.
Thank you. The 10 days then?
It'll be the 29th. This is Sunday, unless you...
I'll do it on Monday.
Okay, 30th.
The 30th would be any opposition to that, and then we'll go ahead and set that hearing 2 weeks thereafter.
February 14th, 9 a.m.
Thank you, everyone.
Have a good day, Your Honor. Thank you.
You too.
Thank you.
Thank you, Judge.
Thank you. Page 8.